Good morning. See, the detention laws, Act 14, Power, PMLA, National Security Act, all these acts are implemented in India when some internal disturbances were uh, deconcentrating the integrity of India. So, therefore, whether to bring these detention laws means without any trial, a person is being detained for a year or 2 years. PTNDPS Act, so many acts are subsequently enacted. So first case was A.K. Gopalan. Case was decided by the Supreme Court when it was challenged. Then they said yes, this is valid. So A.K. Gopalan was detained along with Justice Krishna J. Iyer, a practicing advocate of Kerala High Court, and A.K. Gopalan was a communist. Then, Krishna Jayar was released since state government not approved the detention order within stipulated. But there later on, A.K. Roy case was a well settled law wherein this so many fundamental rights were extended, and thereafter Article 22(5) was also suitably amended uh, to regulating the detention laws, fundamental rights for detention laws. See, young lawyers must understand, I am given to understand, sadly share with you, because several advocates, since they are coming from different background, community, caste basis, people rely them, and lakhs of rupees are being collected, and the detention was not at all challenged. So my young lawyer, my dear young lawyers, primarily what to do, what not to do, I want to discuss with you. Number one, when you are being approached that a person is detained, then immediately you go and try to get copies of detention, because initially there is an opportunity of sending uh, representation even before approval of the state government through the detaining authority, namely the Commissioner of Police or Superintendent of Police, Collector. So unless and until you are served with that copies before 12 days, it is not possible to send. But actually what happens, the superintendent central prisons forcibly obtain signature from the detainees as if it was read and explained every pages, multiple pages. But they only put antedate. But I do not know whether they explain it or not. But it is being countersigned that as if the detentions were explained to the detainee. So normally whenever I file Act 14 cases, I used to plead superintendent prison and imputing allegation that the signature obtained from the detainee was antedated. It was obtained after a few days, at minimum 10 days before the signature was obtained, after the signature was obtained. So that must be one of the. Another thing, even if that period is expired, still you must send a representation to the detaining authority and the detaining authority under the state government confirming authority, and also to advisory board. And when you prefer a representation before advisory board, you must state any non-advocate to be represented before me. And if you want any of the documents which were not properly supplied to you or not supplied to you, and you have that document to be produced, you may request the advisory board to direct the sponsoring authority to serve those copies. Then how to proper representation means you have to patiently read one after another page, and you have to compare the pages, whether any discrepancies are there, whether ipsi dixit. Ipsi dixit means the detaining authority may, uh, while passing detention order, may say some facts which were not available on grounds of detention. All those things are there, so many other grounds are there, but before sending representation, if you send representation, the delay in consideration of representation would be main ground to quash the detention order, and delay in passing the detention order, non-supply of proper copies in legible printing, all these grounds may be there. But sometimes the clients may not be in a position to pay you immediately. At least collect some few amount to prepare this representation, and thereafter you file writ of habeas corpus after collecting the fees. If you are not helping the detainee by sending all these three representations and prior representation before getting approval order, it is too difficult. So my friends, for all these cases, normally what happens, if any person who did not know the language of the state in which the detention orders are being passed in English as well as in that particular language, you have to specifically say how you do not understand or consent with the given language. To simply say that I am Telugu, I am Malayali, therefore I did not know, but this for that purpose there is a citation. And another, they say the detainee has got a fundamental right under 22(5) that the detention order should be communicated to him as soon as may be, and that be offered an opportunity of making representation against the detention order at the earliest. Then they say the detention orders and grounds of detention should be explained to the detainee. If it not properly explained to him, it still is a violation of fundamental right guaranteed under Article 22(5) of the Constitution of India. This is a case of Jaswinder Singh Gaur versus Union of India, 2022, Class 2, Madras Weekly Notes, 67, criminal, page 67, Delhi. Jaswinder Singh Gaur, versus Union of India, 2022, 2, Madras Weekly Notes, criminal, 67, Delhi. See, one thing you all should understand, they say the detention order along with the ground should be supplied within the 5 days of date of detention. But normally, as I told you, the signature is being obtained as if he obtained it within 5 days. For that, the high courts can direct the state authorities to have video recording. I do not know whether, but probably the judges feel that these detention orders are necessary evil. We cannot prevent it. But sometimes the detention orders are being passed against the poor accused from have-nots families. Therefore, that the courts are asked us to wait for months together, that minimum 7 months or 6 months. Thereafter, they set aside the detention order by nagging some points. However, it's all on, because now the field of Act 14 SCP cases are rest with young lawyers, those who are raising up. Therefore, I never accept this unless and until substantially paid and substantial grounds are there, because I know that this is nothing but just like registering with the employment office for seeking employment. Here the detainee's SCP number is being given, and automatically you have to wait for the days to roll on. so that your detention order is set aside. I hope you understand. If kindly go through the entirety of the grounds of detention before sending representation. Concentrate on each page. Best wishes.